Time newscast, the 10 o'clock news, with Amir Makeson, Roger McCoy, Ray Lane Sports, and Gary Basner Weather.
Well, the verdicts in the Malice Green case left many people wondering what actually happens behind closed doors while sequestered juries are deliberating. And joining us tonight with his observations on the Green case is attorney Gerald Thurswell.
Mr. Thurswell, you certainly represent plaintiffs in police brutality cases all the time. Were you surprised by verdicts today?
Not at all. The verdict was not surprising. Watching the events on TV, hearing the testimony, this was not surprising at all.
What do you think would happen? We're talking about Walter Budson and Larry Nevers here. If they were to be going to prison, how are they going to be handled in prison?
Well, they would be put in a low-security prison with people who have been convicted of white-collar crimes. They would not be put in a prison with persons who have been convicted of violent crimes or people that they have put in prison.
What about complaints? People are saying that had it been anybody else, there would be no way that they would be able to have additional freedom on personal bonds. Is this special treatment, and is that okay in this case?
Well, I think as Judge Crockett pointed out, today the verdict comes in. They're not prepared to put them in a low-security prison, a place where they would be safe. And Judge Crockett made that quite evident. In addition, the reason he continued the bonds pending the sentence is because there was no risk that these people would flee, but they would be available for sentencing.
Following up on that, just one question. They were saying that it certainly was no surprise that this could have been the outcome, so they should have been prepared. Do you agree with that at all?
Well, maybe they should have been prepared, but apparently Judge Crockett found that they weren't prepared, and he wasn't prepared to send them to prison with people who had convicted violent crimes.
In terms of the appellate process now, I suppose a lot of people have to be asking the question, Jerry, about at least one juror's comments today, that he felt he had to make a decision under duress. He was fearful for losing his job, and he felt like he was being put pressure upon by other jurors in the case. Is that grounds for an appeal?
Well, you know, they're supposed to deliberate. They're supposed to listen to the opinions of each other, talk about the evidence that they each heard, and if one juror or all the jurors convince the others, that's the way the process is supposed to work. If you talk about duress, threats from the outside for his physical safety, what might happen to him if he rendered a not guilty verdict or a guilty verdict, that's the kind of duress that might be appealable. But just pressure from the fellow jurors, that's part of the deliberation process, where they each share their ideas and what they believe they heard and what should come about.
Judge Crockett has been praised, as I recall, for his actions and the way he carried out this case. Would you care to comment on that?
He was very courageous in the way he handled the entire case, the way he controlled the media, and the way, in the very end, the way he came up with a verdict that he thought was just. He, being an African-American, coming up with the decision that he did, believing from his conscience. He didn't have to give the reasons why he found Lesnow not guilty, but he felt compelled for the community to give his reasons, and they were supported by the evidence, and that was his conscience. And it took a lot of courage.
What do you think might have happened if Nevers and Budson had submitted their jury to the bench, their trial?
You would never know. There's no way to tell. One thing is that the jurors did take 9 days or so to reach a decision, and that shows a lot for the judicial process, that they shared ideas, that they went over the evidence, and that justice was served.
What kind of a bearing do you think this case will have on future cases that might be similar in nature?
Well, as you know, our office handles numerous police brutality cases. Quite often, the police officers get up there and they say that the individual was resisting arrest. This case, and the evidence that was presented, clearly shows that Malice Green wasn't resisting arrest when he was hit in the head 14 times or 9 times. He was lying there and he was beaten to death. Similarly, the Rodney King case. So that in future police brutality cases, the word of an officer that the individual is resisting arrest is going to be questioned. Their word isn't going to be taken for gospel.
Okay, Attorney Gerald Thurswell, thanks very much for joining us tonight with your comments and your observations about the Malice Green case.